Court is back in session. Please be seated. Commonwealth of Pennsylvania versus Claude Lacombe and Michael Witmayer. Ms. Tracy Piatkowski, Mr. J. Bart Malone, Mr. Brooks Thompson, Ms. Lee Aubrey.
Good afternoon. In this direct appeal from the Court of Common Pleas of Montgomery County, the Commonwealth is challenging that court's holding that the retroactive application of the latest embodiment of the Sexual Offender Registration and Notification Act, or SORNA, is unconstitutional. Go ahead.
Thank you, Your Honor. Mr. Chief Justice, and may it please the Court, I am Tracy Piatkowski with the Montgomery County District Attorney's Office on behalf of the Commonwealth as appellant. I will focus my argument on the individual aspects of the cases before the Court, and Mr. DeLone with the Attorney General's Office will talk more broadly about the constitutional issues. The primary issue before the Court in these matters is whether or not Act 29, Subchapter I, is punitive. The answer to that question is no. It's a civil remedial scheme designed to protect the community through information.
How does it differ from Muniz?
It differs significantly from Muniz. In Muniz, this court said that SORNA had too many registrants who had to register too many times and for too long. And the legislature fixed that in Subchapter I.
By nibbling around the edges, right? Not by making a thoroughgoing revision. By cutting down on the reporting and by adding the removal at the back end?
Yes, I think there are four areas that are significant in terms of this court's analysis of whether it's punitive in terms of the reductions. First, it's no longer over-inclusive or excessive. The number of registerable offenses have been reduced from 40 in SORNA to 17 in Subchapter I, so it's more than half of them have been taken off of the statute, and all of them except for two contain a sexual component. And those two, which I believe are kidnapping and luring, I think have an obvious connection to the purpose of the statute, and also were not of particular concern to this court in Muniz.
In the last argument, and I think you were here, we heard that, as Justice Weck said, in terms of interference with custody, the legislature did not eliminate that as a SORNA offense, but rather modified it a little bit. Is that, do you agree with that?
I believe that may be the case with Subchapter H. I don't believe it's included in Subchapter I.
Okay, thank you.
So in addition to reducing the number of registerable offenses, there's also been a substantial reduction in reporting, both in person and in general. Whereas before, an offender might have had to appear quarterly, even if he was not an SVP, that has been completely reduced to a once annual verification requirement. And then in-person updates do not exist in terms of updating information throughout the period in between the verification. So during the course of a year, that can be accomplished through an online form. And that's also only for a limited number of situations. Let
me just understand, I'm sorry to interrupt, just let me understand on that one before we move on. Is it that the one in-person visit, is it that that's not a restraint, or that is an acceptable restraint?
I think it's that it's certainly acceptable. It might be somewhat onerous for an offender, but I think what the court was most concerned about, and it used an example in the opinion in Muniz involving someone who had to go for 100 visits over the course of a period of time, whereas here that's substantially reduced because there is no biannual reporting, there is no quarterly reporting for non-SVP offenders.
Not analogous to saying for probation, I reduce your probation of 7 years till I reduce your probation to non-reporting probation. Are you still on probation? So I guess the question I'm asking is, your argument is because you reduce the number of contacts, it's no longer punitive?
That is part of my argument, because of course the analysis doesn't just look at that one factor of the affirmative disability or restraint. It looks at a multitude of factors. But my argument is that that particular factor has now tipped in favor of non-punitive because of the substantial reductions in reporting requirements. Some reporting requirements are okay, even though they may be inconvenient for offenders, because they further the purpose of the scheme, which is to provide accurate and up-to-date information. So if you have someone who is, in theory, I suppose, a non-reporting registrant, you're not really effectuating the legislature's purpose of providing accurate, up-to-date information, because it's not necessarily accurate and up-to-date if they don't have to at least come in that one time.
Well, isn't the overall purpose the protection of the community?
Yes, that is the purpose, and I think it's effectuated through providing the community with access to information, and the access comes through the registry. And so the purpose of the reporting requirements is not to inconvenience offenders, it's to make sure we have accurate, up-to-date information about them and where they're living. And if they don't move or change jobs or schooling during the course of the year, they don't even have to do any updating during that year period at all. But if they do, they can provide that information through an online form that they can mail in.
So it's the number, by your lights, it's the number of in-person visits that trips the constitutional wire. It's not the removing the person from their daily life, making them take time off from work, drive somehow get to a police station, report and have their picture taken, all of these things being some sort of disability or restraint. It's not, in other words, it's not the qualitative issue from the Commonwealth's perspective, rather it's purely a quantitative thing. Is that what you're saying?
That was my understanding of the primary concern of this court with SORNA and Muniz. Yes, that it was a quantity of the visits. And when you look at the fact that a person, first of all, a registrant will know his annual date, and they have 10 days within that time. So yes, it is inconvenient to have to go to the state police, but it's not as if they can't, plan ahead and make that trip. I mean, we all have to do inconvenient things in our life. We have to get our driver's licenses renewed. We have to, there are all sorts of things that we have to do as part of citizens living in this community. And yes, this is an added thing that convicted sex offenders have to do, but it's okay, particularly because it furthers the purpose of this remedial scheme, which is to provide accurate, up-to-date information to the community about sexual offenders living in the community.
But unlike the Butler case we heard recently, this is non-individualized, right?
That's correct. So these conditions that the statute imposes are based on a legislative policy decision based on, and we talked about this a little bit, or the court talked about this a little bit in the last case, based on legislative findings, which are based on studies, which inform the legislature that sexual offenders as a class are likely to recidivize in a way that maybe some other types of offenders aren't.
We have the SVP provisions.
Yes.
And you heard us talking a little about this last time. So what is this adding to that? Or why does this exist in light of the availability of the SVP avenue? Or is it just to give the Commonwealth another bite at the apple?
Well, I don't think it's to give the Commonwealth another bite at the apple. I think the legislature has made a decision. I think this sort of goes to Justice Donahue's question in the last case. But the legislature has looked at information and made a finding. And we all know that there are studies that go in both directions, right? That say sex offenders are more likely to recidivize and sex offenders are less likely to recidivize. But the legislature has placed value and credence and has found that those that indicate sex offenders as a class, because of the types of offense that they've committed, are more likely to commit recidivist acts. It's not, and I respectfully, Justice Donahue stated that earlier, that it's that they will recidivize. That's not the legislature's.
And that's exactly what the SDP board finds also, not likely to reoffend.
Right.
Same thing. These two people went through SDP protocols. Neither one of them were found to be an SDP.
That's correct. But I think a point, and I think my colleague, Mr. DeLone, made this point earlier, but the finding of SVP is a finding that someone has a mental abnormality, and I'm actually reading directly from the statute.
It says, and the last phrase
Right.
is, and is not likely to reoffend.
As a result of that mental abnormality. So you have a class of offenders who, based on the nature of their offense and statistical information before the legislature has deemed more likely to commit recidivist acts. And then you have a separate statutory-based finding or recommendation by a member of the Sexual Offenders Assessment Board that based on statutory criteria, they do or do not have this mental abnormality, and if they have it, whether it makes them more likely to commit predatory sexually violent offenses. And predatory is important because that's an added word that's not in the legislative findings with respect to the regular offender. So it's a different, so you could have someone who does not have a mental abnormality, I suppose, but is very likely to engage in recidivist acts just because
Based on what? Based on what? If it's not a personality characteristic?
because they enjoy it, I suppose, and like to do it. I mean, I don't know, I don't.
So does that bar our ability to adjudicate individual cases like this because the legislature purportedly has made some legislative finding as to a class, and a pretty broad class?
I think this court has held, and the United States Supreme Court has held, and this court specifically in Lee, and I believe possibly also in Williams too, and the United States Supreme Court, that's okay. The legislature can legislate as a class. And so, and historically that is what it has done. I mean, that's what it has done with respect to.
Well, clearly they can make legislative classifications. I
Right.
suppose my question perhaps wasn't framed correctly. Does it displace judicial review of constitutional challenges of the applications of those classifications?
I don't think it displaces that. I don't think it displaces them. No, I think what my colleague Mr. DeLone said earlier, in this particular case, I mean, what we're considering here, you have legislative findings based on, information, and there isn't a consensus. And I think the jurisprudence is, and as this court stated in Muniz, under those sorts of circumstances, deference to the legislature is appropriate. And I remind the court as well that unlike perhaps in the last case, there was no record here. There were no studies introduced. There was nothing introduced in the court below to suggest to the court that the underlying legislative policy decision was not correct.
So the difficulty, and when you had said there's studies on both sides, for our purposes, it's the record. We don't get to look at things outside the record. Now, we do have the legislative findings. We certainly look at that as a matter of statutory analysis. But that's all we have in this case. So I guess that inures to your benefit.
I'm sorry?
I guess that inures to your benefit, that the other side didn't put in studies to show that the legislature's determination that sexual offenders are dangerous to society has
Right.
been rebutted in this case.
Well, I thought the question here was, notwithstanding the legislative adjustments, is the statutory regime still punitive?
Right, and the Commonwealth's position is that no,
It
it's
doesn't have anything to do with legislative findings or anything.
right.
Right? Legislature changed the statute in light of some opinions in this court.
Correct.
Or an opinion.
Correct. And so the answer is that it's no longer, I mean, to the extent this court had issues with the SORNA statute in Muniz, those things have all been fixed here. And I've outlined in my brief, and I started explaining all the specifics of what's been changed, but at the end of the day, there's shorter registration periods, there's fewer offenders who are affected, there's less frequent reporting, and so the legislature answered this court's decision in that case.
Unless the court determines that it is lifetime, and I don't think any of us were overly impressed, I can't speak for my colleagues, with an opportunity to reopen this 25 years later, which is a lifetime. But that the idea of lifetime registration, or what's the second class, 25 years?
10 years.
10
So
years.
under
10 years or
subchapter
20
I,
or lifetime, right?
it's 10 years or lifetime, and the lifetime registrants are for the more serious offenses. They're graded higher. They're the rape, the IDSI, the felonies of the first degree, and the 10-year is for.
And I admit
the
I'm
less serious.
thinking out loud, but how do you respond to the argument that put everything else aside, that when you say to a sexual offender, not an SVP, not an SVDC, a sexual offender, lifetime registration, that in and of itself makes this punitive? It's just too onerous a requirement.
Well, there's no precedential authority for that specific notion, and I can certainly understand why it might feel that way to an offender when faced with that prospect. But we have to keep in mind that these are consequences that result from the offender's underlying act, and it's a serious act if it's a lifetime registration of sexual, a serious sexual act and a crime. And furthermore, I do think...
I'm sorry to interrupt you, but that you're going right back to where the last case was. You begin to make it sound as if it's a sentence. It's fine if it's a sentence, but then it's criminal and not civil collateral consequence. So how do you argue it without making it part of the sentence?
Well, I think it's not excessive relative to the underlying offense, but I think this court, with all due respect, may be minimizing the value of the 25-year removal mechanism. I mean, this court in Williams and in Lee said even without the removal mechanism, lifetime registration for SVPs was not constitutionally problematic. Now, we're not talking about SVPs.
In the legislature in this case, from what I can glean, mimicked Megan's Law 2 on a justification that Williams 2 upheld it. But what it seems to have missed is that Williams 2 upheld it as the SVPs, and this is an SO case.
I agree with the court. The issue before the court in Williams 2 was SVPs, but I think reading that opinion, some of the analysis also considered the non-SVP factors.
Counsel, if I may.
Yes.
Share with me and help me understand this. The concept of the registration is for community protection because the General Assembly has deemed them recidivists.
Well, not actual recidivists, with all due respect.
Potentially recidivists. But
More likely to recidivize than other classes.
yet it takes away the discretion of the future trial judge. Should that individual recidivate, we're not going to be worried about whether he or she registers because if I'm the trial judge and it's the second or third rape, that individual may never see the light of day and will die in prison with the sentence I give him. So with that being stated as a result of enhancements, why should we consider your request not to be, as Justice Baer said, just a protracted sentence or a nice way of calling a civil remedy truly just an extension of the sentencing code?
Well, I think there are a couple of different issues I think the court touched on with that. First of all, the purpose is to help people potentially prevent being victims of recidivist acts. So even though the court can subsequently sentence an offender who recidivizes to a lengthy period.
Isn't that why the General Assembly created maximum and minimums for criminal conduct? Don't you think, I would think a deterrent to committing a second rape would be that you may have to come in front of me as a trial judge and I'm going to roof you. Not whether you're registering your name and address. Your address will be at a SCI somewhere in Pennsylvania with me.
Presumably. But the purpose of the statute isn't to prevent recidivism. It's to inform people in the community of the potential for potential sexual predators in their neighborhood.
And to protect them and their children.
Exactly.
Which is the basis of our criminal jurisprudence, that we commit individuals' incarceration to protect the community. It's a factor we consider under the sentencing guidelines.
It is one fact that the court considers, but it also considers other things like rehabilitation and allowing offenders to come back into the community. I think there's more that it's looking at than the community protection focus, which is the focus of this remedial scheme. So when I'm thinking, I know in the Muniz case, the court talked about that SORNA was akin to probation, and there was a discussion about that. And I wanted to respond a little bit to that today in terms of subchapter I, because I think there are critical differences between probation and registration that might illustrate or help shed some light on your question, Justice Doherty.
Wouldn't it feel a lot like probation when over the course of that 25 years, you reported, what would you report, a few hundred times in person?
No, over the course of 25 years, you would report 25 times in person.
What if, there are different categories, aren't there, though?
Not under subchapter I. So subchapter I, so under SORNA, there was I believe it was 15, 25, and lifetime for non-SVP offenders. And then there were more frequent reporting requirements over the course of that 15, 25 lifetime period. So you could have people who were, 15-year registrants who had to report maybe twice a year based on their underlying offense. And so that then you're talking about 30, you're talking about more frequent. Plus, they had to do the in-person updates, which are not part of this scheme. So it really has, and I provided examples in my briefs to the court in each case that, for example, someone who was convicted of unlawful contact with a minor under SORNA had to register for 25 years, report twice a year for verification, and do in-person updates. Under the new statute, under subchapter I, they register one time a year for verification and have no in-person updates and 10 years of registration. So you're reducing that from 50 visits to 10.
Unless you're in a temporary habitation, right? Then you come in
Right.
every 30 days in person, right?
Right, so you're talking about the transient provisions.
And the reporting that can be done by telephone or otherwise, I'm not really sure how that works. How often does that take place?
Well, telephonic reporting is not part of subchapter I, that's part of subchapter H.
Okay.
So there's no telephonic reporting in subchapter H, in subchapter I. But in subchapter I, you only have to report annually. There's no more frequent verification that you have to do. So there is, I believe, in subchapter I. So
If you change your home or change your residence or going out of town on vacation, you don't have to report that?
if you change your residence, you do have to report that, but you have 3 days to report it, and you can do it from the time that you actually physically change the home, and you can do that by way of a mail-in form.
Use a mail-in form?
Right, and that's the kind of life change that presumably, most people see coming. Maybe if you're suddenly evicted, then you have this sudden 3 days where you have to let the state police know, but usually when people are moving from one location to another, they have a little advance warning, and so there's really nothing particularly punitive about the idea that you'd have to fill out a form and mail it into the state police. I mean, you're going to have to notify lots of other people when you move too.
Do you
So,
have to notify if you change your job?
yes, employment, school, and residence are the three things that you have to do a notification about, independent of your annual verification.
And if you don't report within 3 days, it's a crime.
Yes, you can be prosecuted
Felony.
for failing to make those notifications. But again, you can mail in a form that provides that information within the 3 days, and if it's postmarked in that period, I mean, this isn't, and like I said, you probably know that move is coming. So, in terms of the transients, which I believe Justice White, I apologize, asked me about, I think, first of all, transients are a very, very small subset of offenders. I mean, I looked on the website yesterday, and we're talking about 262 transients out of 21,000 registrants. So it's a very small subset, but they have special considerations in the same way that SVPs have special considerations. But they if the purpose of the scheme is to protect people in the community, if you have a sex offender who is moving around or does not have a permanent place to live, the idea is that they need to be letting the Pennsylvania State Police know more frequently where they are so the state police can provide accurate and up-to-date information. And so I think there's a different consideration for those types of offenders.
Refresh my recollection. In that circumstance, will the state police not only update the registry, but they will directly report to certain individuals? Like, for example, the victim.
There are
the
certain
original
victim notification provisions.
And if someone has gone onto the website and said, I'm tracking this guy, let me know if he ever moves, then the state police would identify
get
that person
notification.
and notify the person who has asked someone to be tracked by way of the registry.
I believe that's correct. But that actually brings me to one other point I wanted to get to, which is the internet provisions, which I know was a concern of this court in Muniz. And the court was concerned about this idea that an offender's information could be sort of broadcast worldwide with no mechanism for rehabilitation. And so I wanted to just pick that apart very briefly to talk about why I think that factor actually tips in favor of non-punitive. First of all, it is not an active system. It is a passive notification system. It does not, with the exception of certain people who've asked to be notified, as a general rule, it's a repository for information that's available online. And if I want to find that information out, I have to go actively to the website. I have to accept its terms. I have to read the warning.
Is that true with every website? And I'm just asking this sort of as a general consumer of websites. If I go on to a website, generally speaking, it's going to ask me if I agree to its terms and conditions. And if I say yes, then I could continue to use it. If I say no, then I can't. I mean, you're talking about this as though this is an extraordinary mechanism by which access is restricted. And I'm just testing that premise.
This might be a little outside of my area expertise sort of in general in terms of websites, but no, that has not been my personal experience, that when I go to different websites, I have to accept its terms. I mean, there are definitely some times when I have to click that I'm accepting things.
Well, that's one, that fair as far as it goes, I grant you, but doesn't that presume doesn't that sort of engage in the fiction that anybody is only going to follow this one avenue? They're going to go only to this website, as opposed to just Googling, just performing a Google search. No promise is necessary to Google the name and come up with all sorts of ways. You're going to find out people living within X miles of your home probably just by a simple Google search, having made no promise not to harass.
Right, but incidentally, as we know from the Crime Watch amicus brief, if you do a Google search for a sex offender, you will not come up with the Megan's Law website. So in fact, I did a search yesterday for one of the defendants here, Claude Lacombe. You do not come up with Megan's Law. And it's explained very well, I think, and I'm not going to get into the technical terms about spiders, but the bottom line is that information on the website is not Googleable. You have to go to the website.
Let me just ask, just for educational purposes. In order to, a user goes to the website, the registry.
Yes.
They have to know the name of an individual that they're looking for?
No.
No. So they could go to one place and browse through the names of 22,000 people in Pennsylvania who have been deemed more likely to recidivize than others in one place. And without knowing the name of anyone in particular, they could then say, how about Allegheny County? And then they could see the names of all of the individuals in Allegheny County who have been deemed by the legislature more likely to recidivize than others, and just pick those people apart. How about my neighborhood? And then, or suppose I'm just sort of interested in how many registrants there are in Juniata County, my favorite county this session. I could go to that registry and I could find out how many people there are without having any particular interest in one person. I could just browse this registry to determine who has been deemed by the legislature more likely to recidivize.
Right. But I suggest that you could get that information the same way, even if it wasn't, not as easily or not as conveniently.
If I just say, geez, I wonder how many sexual offenders there are living in Dauphin County.
You would contact the state police and ask them because they would have that information. It just wouldn't be on the internet.
Why bother? I could go to the website, click a button and say, I won't harass anybody with this, and then just browse to find who there might be.
I'm saying if we didn't have the website, you could still do the things that you'd suggested. It just wouldn't be as convenient.
So why have the website?
Because for one thing, and that this point was made, I think, very well in the Attorney General's brief, it sort of democratizes the process. It makes it easier for anyone to be able to access the information, which is the point of the scheme, is everyone should be able to have access to that information. So in today's world, I think it's fair to say that virtually everyone has access to the internet. I mean, the court agreed with that in Eunice. People have access to the internet. Even poor people in difficult neighborhoods, even homeless people often have phones with access to the internet or can go to a public library to obtain that information. They should be able to obtain that information about sexual offenders in their area just as much as someone who can afford to have a private background check.
Well, and isn't that in furtherance of the goal of protecting the community, that if you live in a particular community and you have 3 small children and you're going to allow them out to play or go to events or whatever in your community, that part of this legislative scheme is that you as a parent or concerned individual can go to this website and determine, are there sex offenders subject to this registry in my neighborhood?
Exactly. I mean, that's exactly the point, is to enable people to have the ability to do that. And the internet, putting that information on the internet just makes it more convenient for people to do. It doesn't change the information, and it doesn't change that a person could obtain it. It just makes it easier.
Can I follow up on Justice Todd's question? So to protect the community, those years go by, and at the end of, in this subchapter, we're talking about 10 years? 10 years.
There's 10 years and lifetime registration.
Right, and lifetime. We're talking non-SVPs.
Yes, non-SVPs.
So at the end of this period, one of these folks is on this website with his photo and his address, employer's address, etc. And he's going to come forward under this subchapter and prove by clear and convincing evidence that he's no longer a danger, right? How does he go about establishing by clear and convincing evidence that after all these years gone by, because the burden's on him to get himself off of this, to take the mark of Cain off himself. How does he go about proving that?
Correct. Well, I think the same way he goes about proving the point is, he's trying to prove that he's no longer likely to be a danger. I mean, we can never know with anyone, even with the people we deem likely to recidivize, whether someone's actually going to commit a recidivist act or not. We can never actually know that they're not. We can only sort of make predictions. But first of all, the statute provides a very specific statutory scheme. They have with a process that enables them to do this. They have an evaluation by the Sexual Offenders Assessment Board. And there will be presumably statutory criteria that they are looking at to determine whether or not they are likely to pose a threat to the safety of others. There's a hearing process. They are entitled to counsel. They are entitled to appellate review. And I also think, with respect to the 25-year mechanism, the passage of time without reoffending would be a very valuable piece of evidence to present at that hearing to suggest that they are no longer a danger. So I think that's one of the reasons 25 years makes sense in that context.
Here, an individual assessed by the SOAB, not deemed as sexually violent predator, but is a sexual offender and must register after the 10th year, they could submit that SOB evaluation saying, here, I'm not likely to reoffend because it was determined 10 years ago that I wasn't?
Well, the statute only provides for a 25-year removal mechanism.
Okay.
So,
It's even better. After 25 years, is the evidence, since the burden falls on the individual to prove that he or she is no longer, why could he or she not submit the former SOAB board evaluation indicating that they are not a sexually violent predator, they were not deemed likely to recidivate?
well, I think, just to be clear, I think when the court initially makes the SVP decision, and assuming that the board made a recommendation that they were not, did not meet the statutory criteria for a sexually violent predator, that is a different analysis where you're looking at the mental abnormality that's not present in the overall statutory scheme. So they could certainly present the evidence that they didn't have the mental abnormality as helpful evidence at the 25-year mark hearing to suggest that they are less likely to pose a danger, or I'm sorry, less likely to, pose no longer a danger to the threatened safety of other individuals. That certainly would be compelling evidence. But I think it's an important point, and I make it in the brief, that there's no reason to think that this removal mechanism won't work. I mean, there's no reason to think that a judge in the Court of Common Pleas, especially after 25 years of no criminal conduct and no recidivist act, wouldn't be able to fairly assess the evidence that hears at that hearing and make a finding by clear and convincing evidence. I don't see why it's assumed by my friends in their briefs that would be the case. And the court below assumed that too, that it was an illusory mechanism. It's
an assumption if it's no criminal contact after 5 years, 10 years?
Maybe you could, but that's not what this statute provides for. This statute only provides for...
But if this statute's deemed unconstitutional as punitive,
Next try.
then what?
Well, then I guess the legislature goes back to the drawing board and makes some different choices. But I think
we're going to take a look at this. As we understand, you've taken us through the statute in exquisite detail. The thrust of your argument is that the legislative adjustments solve the constitutional problem. And you've given us the descriptive example of how that occurred. Is that correct?
yes.
Lone, do you have anything to add to this? Because want to take your time, but we're obviously familiar with SORNA.
But I'll be very quick when I get there.
Yeah.
Thank you, sir. Mr. Chief Justice, and may it please the court, Bart Delone back again. I promise very briefly. I will not be repetitive with Ms. Piatowski, and I will try and not be repetitive with myself earlier today. I will address a couple of things that haven't been addressed, which is the Apprendi arguments, and I would refer the court to the citation to this court's decision in Resto and Oregon v. ICE to suggest that there is no additional predicate fact, so Apprendi is not applicable. I would also refer the court to People v. Mosley, where the California Supreme Court went through the analysis specifically in the context of their SORNA statute. I'm going to skip ahead a little bit. On the separation of powers, I think our brief is pretty clear that there's a judicial determination here and the best kind of panoply of due process protections, which is the criminal trial to begin with, and that there's no problem with the separation of powers. If I could just conclude, everybody here today seems to be referring back to an amicus brief. I would ask that the court pay special attention to the Pennsylvania District Attorneys Association amicus brief that talks about a wide range of regulatory schemes, not just this one, not just criminals who can no longer have firearms, but a whole series of other schemes, and suggest that given the digital world that we live in, that a reflexive view that publishing constitutes punishment in whatever form would be a severe blow not only to SORNA and Act 29, but to our modern regulatory system. And I really want to thank the court for its indulgence in listening to me twice.
Mr. DeLone, before you sit down, may I ask you one question?
You bet.
Chief, okay. And I saved this question for you because you argued both Torricelli as well as this case. Do these cases, in your estimation, rise and fall together? So that if we say that subsection H in Torricelli is unconstitutional, that we necessarily reverse here?
Oh, absolutely not.
They're completely discrete in your view?
One of the things we said at the very beginning of our briefing with respect to subchapter I is this court spoke in Muniz and the General Assembly listened. And I think my co-counsel did an excellent job of describing the fundamental differences between subchapter I and subchapter H. And I think the General Assembly was first efficient and pretty dutiful in looking back at what was concerning to this court. So if you want to make a different conclusion with respect to each of the provisions, you not only could, but you should.
All right. I thank the Chief Justice. I thank you. It's difficult in the time provided with 21 cases on the list to appreciate all the nuances between H and I. And we're going to have to go back and do that, but do that when we have more time.
Chief, may I just ask one follow-up question? Yeah. Thank you. If we decide that the failing in subsection I, is that the term?
I'm sorry, could you speak up?
If we find the failing in subsection H is its lack of individual assessment, does an analysis of subsection 8 of this subsection I require the same conclusion?
No, I don't think it does because of the differences and because of all of the other factors that have been discussed here today. I think the analysis would have to be independent for each section.
Notwithstanding the fact that this also is not individualized.
Yeah, I mean, I think that's key to the due process questions. And I think, as I said, I was trying to not be repetitive with the court from what I said this morning, but obviously a lot of the same arguments are made in both of our briefs because a lot of the analysis we would respectfully suggest is the same. And I just think the General Assembly did their best, and with all due respect, since I got to speak on both, I don't think either subchapter I or subchapter H is clearly, palpably, and seriously unconstitutional. Thank you so much.
Thank you.
Thanks.
If it may please the court, my name is Brooks Thompson. I'm from the law offices of McMahon, Lentz & Thompson, and I'm here on behalf of appellee Claude Lacombe. Your Honors, what I intend to do is address generally some of the distinctions with subchapter I and the statute considered by this court in Commonwealth versus Muniz. And then my colleague who is on the Witmayer case will get into some more of the specifics and in particular comparisons with subchapter I with Megan's Law 2 and Megan's Law 3 as in her case. But to start off with, Your Honors, I think it's important to note that Mr. Lacombe's case really speaks to the concern about the lack of an individualized assessment in this broad brush that we paint everyone as being a likelihood of future harm, even if they haven't been designated as an SVP. Mr. Lacombe, at the time of his offenses and at the time that he was convicted, Megan's Law 1 was the statute that was in effect. Under Megan's Law 1, Mr. Lacombe was presumed by statute to be an SVP unless and until he presented clear and convincing evidence that he was not an SVP. Mr. Lacombe satisfied that burden in this case in the first instance. He presented that clear and convincing evidence that he was not an SVP. So I think that goes to illustrate the problems with painting all of the offenders with a broad brush when you have an individual who has had an individual assessment and has presented evidence that he is not within that SVP designation. The Commonwealth refers to the changes, and there were changes in subchapter I with respect to the reporting requirements, but I would submit to your honors that those changes are not sufficient and they're not substantial in any means. With respect to the verification, the Commonwealth argues that, well, no longer are registrants required to appear in person to update their information if they move, if they're terminated from their employment, if they change schools, enroll in a new school. No longer are they required to appear in person. But the statute, if you look at the text of the statute itself, it doesn't actually provide a specific method of notifying the Pennsylvania State Police of those changes. It seems that it's to the discretion of the Pennsylvania State Police. And the Commonwealth referenced and provided a link in the district attorney's brief. There was a link provided to the Megan's Law website where a mail-in form could be found. Well, that mail-in form is what the PSP decided in their discretion was the an acceptable alternative means of notification. But that was within their discretion, within the discretion that the statute gives them. And on the form, it says that at the top of the form, if you view it, it says any inaccuracies in completing this form will cause or could cause delays in processing, which could or would cause you to be, essentially delinquent and be punished under the criminal statutes. So, Your Honors, they require a very specific form to be filled out, and they decided that within their...
What's wrong with that?
Well, Your Honor, it illustrates, there are several things, but the first thing to the point that I was making, it illustrates that the statute leaves it completely open for them to decide what the mechanism for notification is. In other words, they could change, there's nothing in the statute.
That's your argument as to why the statute's unconstitutional.
No, Your Honor, that's with respect to that factor. So the other point is whether or not that's a meaningful change. So if we're allowed to mail the form in, but yet if the PSP does not receive that form within 3 days, we're punishable by a felony, I would submit that it would almost be reckless to say, I'm going to rely on the mail, rely on this being received by the PSP within the time allotted. I'm going to rely on that knowing that this is punishable.
What should the legislature have said within this statutory framework?
That would have been better. The legislature could have provided a meaningful alternative means of reporting. They could have specified also a longer time period. 3 days, that's similar to the probationary argument. So that's with respect to the 3-day reporting. I won't spend a ton of time on the internet posting requirement because, frankly, I don't think there's been any argument that the internet registry or the internet notification procedures are any different under subchapter I than they were under SORNA, which this court...
The difficulty is, given it a fair amount of thought, how can they be? The internet is pervasive, but the internet is what we have in today's world.
That's true, Your Honor. There could be limitations on the extent of the information provided. I thought about it some too. There could be perhaps a means of limiting the scope to your geographical region, where you can only search offenders in your geographical region. Maybe you could contact the police and get a code that would allow you to only search. The other thing is with the broad scope of the registration requirements, yeah, it has that warning on there that says you could be punishable by criminal penalty if you use this to harass or stalk someone. But if someone in another country can access this information and distribute it to people in the United States or anyone outside of the reach of the jurisdiction of the criminal penalties, I mean, that's a relatively meaningless warning, I would submit to Your Honor.
It is the legislative prerogative. If I live in Paris and I'm moving to Philadelphia for work, and I have young kids, I don't want to move in a neighborhood with a sex offender. So I access that and I make sure I don't buy a house there. That's a laudatory, notification, reasonable notification by the legislature. So it's okay, you can move on. I don't want to belabor it. I just can't figure out a different way to do notification.
Understood, Your Honor. The Commonwealth argued that the statute is less broad in terms of the offenses that it includes, subchapter I, and that is true, but it still includes offenses which have no element as the criminal offense of any type of sexual nature, kidnapping. If a person kidnaps for ransom under the statute, they're required to register as a sex offender. They're presumed to be at risk for of committing future offenses merely because they committed...
That's pretty generic. You have a client, so you're mounting a challenge to the statute on behalf of your client.
Understood, Your Honor, but I was just, in terms of the overall statutory scheme
you're worried about the other
punitive analysis.
clients for other people.
I understand. And with respect to my client, Mr. Lacombe's registration requirements would have terminated back in 2015. He would have been a 10-year registrant under Megan's Law 1. Again, deemed not to be a sexually violent predator, and there's been no intervening criminal offenses, and yet here we are. And I think that the court, I won't go into them, I think the court picked up on the concerns with the 25-year removal.
Before you sit down, just really briefly, they've made an argument that you don't have any on-ramp, that this is an untimely PCRA. You can't file habeas. You guys no longer in jail. You can't file PCRA. How do you have standing to be here?
Well, Your Honor, I believe that this is clearly answered by the PCRA statute. The PCRA statute sets forth the lists of claims that may be brought under the PCRA. And, those relate to a violation of the Constitution that undermines the guilt.
Exceptions to the one-year jurisdiction.
No, just in general, just the cognizable claims under the PCRA Act. There's about 7 of them. The majority of them relate to the underlying determination of guilt or not guilty. And my argument here is based on an argument actually of the Superior Court in Commonwealth versus Rouse. It was a 2018 decision. But basically, the only provision, the only claim that may be brought under the PCRA that relates to sentencing that does not in any way relate to the determination of guilt or innocence is subsection 7, and it says the imposition, that's for where the imposition of a sentence is greater than the lawful maximum. That's certainly not the claim we have here. Your Honors, the PCRA Act did not contemplate claims where the challenge to the sentence was not based on the sentencing discretion of the judge or the process or procedure in which a sentence was imposed. This is a challenge to that is what the PCRA Act contemplates. They did not contemplate a challenge, like in this case, to the constitutionality of the statute. The enacted legislation.
Wouldn't your better argument be that with respect to a retroactive adjustment to punishment, the one-year period starts to run when the legislature acts?
I was going to get to that, Your Honor. Yes, and that's exactly the point. Just like with a probation violation, if a new sentence is imposed upon a person after they violate probation, the one-year limitation begins to run from when that new sentence is imposed. So to the extent that it is a PCRA and it is a sentence within the PCRA Act, then that one-year period would start when that sentence was imposed.
Counsel, one more thing. A few minutes ago, you were pointing out that your client, like your co-counsel's client, that Lacombe and Witmayer are both non-SVPs. They were not found to be SVPs. And you were pointing that out by way of your challenge here. How would you respond to Ms. Pietkowski's argument that the SORNA and the SVP are dealing with different issues, that they're qualitatively different, that they manifest qualitatively different legislative concerns?
Your Honor, I don't know that they do. I read the SVP section to basically be concerned with people who are of risk of future offense on the basis of mental abnormality, which is, I think, what's sort of presumed in the legislation for non-SVPs. In other words, I forget if it was Justice Donoghue or Justice Baer, what is the basis for making that determination? And it seems like the The legislature, with respect to the SVP, is saying that it's because of a mental abnormality. I think that applies to the, across the board. Otherwise, why are we saying these people are at risk of future criminal offenses? And again, especially when you have a case like Mr. Lacombe, where he actually presented evidence to the contrary to show that he didn't have a mental abnormality and was not at risk for a future offense. And he presented that evidence as he was required to rebut the statute under Megan's Law 1.
Thank you.
Thank you, Your Honor.
Chief Justice and Your Honors, may it please the Court, I'm imagining we're all a little sorted out right now, so I will try and go somewhat quickly, but I do want to hit on a couple of points. The first of which is, this court may affirm on any basis the decision below, and so the arguments that were made with regard to due process and in the Torsiglieri case would also go to my client should the statute be deemed unconstitutional. And while I did hear Justice's concerns about the record in our case below, I do note that we are against the same parties, similar parties, and those same parties in our case did stipulate to the record below in Torsiglieri. So I also want to point out that Mr. Witmayer presents some interesting fact patterns on the Apprendi issue, and I won't belabor it, but one of the interesting facts that's present in my case is that the bills of information actually, when the prosecution was putting my client on notice about the charges that were going to be brought against him, gave a range that extended to December 27, 2012. And of course, you all will recognize that could arguably push him into subsection H. That there was no finding of fact by a juror with regard to that date. There's no finding of fact with regard to the actual date of the offenses. So that leaves significant ambiguity as to where he falls. Now, in this case, all parties kind of came to an agreement. There seems to be no contest that subsection I applies to my client, but that could play out in a number of ways, and it just kind of shows how that factual determination is not a discretionary aspect of sentence. It really goes to the heart of what kind of punitive measures will attach, assuming that this court does deem subsection I
Did he ask for a jury determination?
On subsection I?
On the date, the issue you just raised.
No, Your Honor. I mean, it was this came up after the fact, right? So the jury was looking at there was some examination as to dates with regard to alleged offenses. I imagine whenever we're dealing with offenses that go to the age of a child or something like that, you might have to look at a date range to prove those elements. But there's no proof beyond reasonable doubt.
I guess you wouldn't have had to ask for it. You're saying that's the Commonwealth's burden.
Yes. But assuming that we are here today to discuss the ex post facto application of the statute, which of course would require this court to find subsection I punitive, should it not find it unconstitutional on other grounds, I do want to hit on a couple of the facts that were brought up. The Commonwealth seeks to relitigate the internet provisions. I don't know that there's a question of the internet as needing to be a modified source of providing information. I think the fact that it's so broadly disseminated was a factor in assessing the punitive characteristics of subsection I. That said, we all want access to information, but we also want that information to be reliable. And over-inclusion precludes the reliability of that information. I, as a mother, don't want to be informed of false or exaggerated dangers. That dilutes my ability to respond. Some of that over-inclusion is not just in the charges such as kidnapping that my counsel pointed to, but also the lack of any kind of individualized assessment. I also think the Commonwealth greatly minimized the reporting requirements, not just with regard to what one would have to do to give proper notice within 3 days without facing criminal charges, but also the transients. We can look at this current number and see how many people are transient and say, oh, it's a small subset. But over the course of one's lifetime, those numbers add up, and we don't know exactly how many people will experience some period of transience during the course of their lifetime reporting requirements. If I'm transient, I not only have to get there to report in person,
Your
Excuse me.
client a transient?
My client's currently incarcerated. When he gets out,
He's not transient.
yeah,
He will be.
What do you,
we don't know. We don't know. We don't know what's going to happen to him in 5 years, 10 years. We don't know who he's going to be. We don't know what kind of risk he's going to
He's
pose.
probably not moving in with you and your kids.
Well, that's a choice that I can make, and I have to use my individual capacity to assess the people that I meet. And if I give myself a false sense of security, that because I see someone's name on a registry, that all of a sudden the other people who are in my circle are not offenders, then I'm not taking care of my son. We can't preclude the possibility that he will be homeless or transient, relying on temporary housing. We know that as a Tier 3 offender, he will not be able to rely on federal housing. We also know that he will have to report not just his living location, if he's in a particular park, but also where he eats, frequents, engages in leisure activities. And there's no exception.
I think you're hurting yourself. The legislature's need to keep track of a sexually deviant child, a SVP, a transient, are all markedly different than a sexual offender. I mean, you're here with the best possible facts, and I think you're sort of grafting onto them facts that are more difficult.
Well, it's interesting because I think that reveals a built-in irrebuttable presumption that we're not talking about, but that is alluded to in the Commonwealth's brief, which is that somehow reliance on temporary housing or being homeless makes you more likely to offend, and that too is an irrebuttable presumption. I believe that the
rational conclusion of the legislature is it makes it necessary, once you've committed a sexual offense, for society to keep a closer eye on you.
Absolutely, to be able to track. But if we're talking about the punitive characteristics of those requirements and the Commonwealth
We
is getting
understand
into
what
the
the
amount of
case
numbers. Okay. Thank you, Your Honor. With that, I will respond to
Thank
any
you.
additional questions. I really do appreciate your time making these considerations.
thank you.
Better
Thanks
argument.
to all of you.